If you think you're safe because you use marijuana legally in your state and you own firearms, this new ruling from the Supreme Court on June 18th just changed your legal landscape. But probably not in the way most of what you are reading right now says it did. And if you think this ruling gives you complete, blanket, comprehensive protection to own and possess firearms regardless of your marijuana use without any remaining legal risk, you are reading it wrong. That misread could cost you your gun rights permanently. So subscribe right now and let me walk you through exactly what the Supreme Court said in United States versus Hemani, every word that matters, every word that does not, and every gap between what the ruling covers and what it leaves open. Because the gap is where the legal risk lives for millions of gun owners who use marijuana. Let me start with what the source text gives us and nothing else, because this channel operates on verified information rather than wishful reading of court decisions. The case is United States versus Hemani, decided June 18th. The vote was 9-0. That is unanimous. Every conservative justice and every liberal justice agreed on the result. The ruling declares that the federal government cannot strip a person of their Second Amendment rights simply for being a regular user of marijuana. And the court's stated basis for that ruling is that a blanket ban on firearm possession for unlawful drug users lacks historical justification. That is what the source text says. Every word of it matters. Let me now go through those words with the precision this ruling deserves. The first word I want to address is simply, the federal government cannot strip your Second Amendment rights simply for being a regular marijuana user. In legal writing, the word simply is not a casual qualifier. It is a term of legal art. It defines the outer limit of what the ruling addresses. Simply means by itself, alone, based on nothing else, as the sole and sufficient basis. The ruling says that marijuana use alone cannot be the only reason the government strips your rights. It does not say the government can never restrict a marijuana user's gun rights. It does not say marijuana use is irrelevant in all legal contexts. It draws a line that says, this one thing standing alone is not enough. But it deliberately leaves open the question of what happens when other factors are present. Why does that matter? Because there are many scenarios involving marijuana and firearms that involve more than just simple regular use. Someone who is actively intoxicated while armed. Someone whose marijuana use has progressed to the level of genuine addiction. Someone who has a documented pattern of dangerous behavior combined with drug use. Someone who is using marijuana in conjunction with other controlled substances. For any of those scenarios, the ruling as described in the source text may not provide the same protection it provides for the narrowest case of a regular recreational marijuana user who owns a firearm and has never done anything dangerous. The source text does not resolve those harder cases. The word simply is the court's way of leaving them open. The second critical phrase is regular user. The source text says the government cannot strip rights for being a regular user of marijuana. Not a user of any kind. Not any person who has ever used marijuana once. A regular user. The source text does not define regular. It does not give you a frequency, a quantity, or a pattern that distinguishes regular use from other categories of use. This definitional gap will be filled by future litigation. Courts will have to apply the Hemani ruling to specific factual situations and determine whether the drug use pattern in front of them qualifies as regular use within the meaning of the ruling, or whether it crosses some threshold into a different legal category. Until those cases are decided, anyone who uses marijuana and owns a firearm is operating with some uncertainty about exactly where the legal protection of Hemani begins and ends. If you are finding this important, subscribe right now. The Hemani ruling is one of the most significant Second Amendment decisions in years. It is also one of the most misunderstood. And the misunderstanding is happening in both directions simultaneously. Some people are treating it as a complete get-out-of-jail-free card for marijuana users who own guns. Others are dismissing it as narrow and meaningless. Both are wrong. The truth is more nuanced and more important than either of those readings. Subscribe so you get the accurate version every time. Now let me address the third key phrase. Blanket ban. The source text says the blanket ban on firearm possession for unlawful drug users lacks historical justification. Blanket ban is a legal term that means a categorical, across-the-board prohibition that applies to every member of a defined group without individualized assessment. The ruling is striking down the blanket application of the drug user gun prohibition. It is not striking down every possible restriction on drug-using gun owners. It is striking down the specific mechanism of saying if you are in the category of unlawful drug users, your rights are automatically gone, with no individualized evaluation of your actual danger, your actual impairment, your actual situation. The word blanket signals that the court's objection is to the categorical, automatic nature of the disarmament, a restriction that requires the government to show something specific about this particular person, something that demonstrates actual danger or actual inability to safely possess a firearm, might survive the ruling. A restriction that automatically disarms every person in a category based solely on their membership in that category, without looking at their individual circumstances, is what the ruling strikes down. That distinction will drive an enormous amount of litigation in the years ahead as courts try to figure out what a non-blanket drug-related firearm restriction would look like and whether one can be constitutionally constructed. The fourth phrase is lacks historical justification. This is the constitutional test the court is applying. Based on my knowledge of the legal framework, and I want to be clear that the historical justification standard is identified in the source text as the basis for the ruling. While the specific framework is my additional context, this is the Bruin historical tradition test. The Supreme Court's 2022 decision in New York State Rifle and Pistol Association versus Bruin established that any restriction on the right to keep and bear arms must be consistent with the historical tradition of firearm regulation in the United States. The government must identify historical analogs from the founding era that are relevantly similar to the modern restriction. If no such analogs exist or if the analogs are not close enough, the restriction fails. The Hemani ruling, as described in the source text, found that a blanket ban on firearm possession for regular marijuana users lacks the required historical justification. The government could not point to founding-era laws that disarmed all members of a drug-using category across the board, automatically, without individualized findings of dangerousness. The source text does not describe what historical analogies the government offered, or why the court rejected them. But the bottom line in the source text is clear. Historical justification is lacking, and therefore the blanket ban, as applied to regular marijuana users, cannot stand. Now let me address something that the source text does not mention, but that is critically important for every gun owner who uses marijuana to understand. I am identifying this as additional context beyond the source text, and I want to flag that clearly so you understand the difference between what the ruling says, as described in the text, and what related legal questions remain unresolved. There is a federal background check form called ATF Form 4473. When you purchase a firearm from a federally licensed dealer, you fill out this form. Question 21E on that form asks whether you are an unlawful user of or addicted to any controlled substance. Marijuana, under federal law, remains a Schedule I controlled substance regardless of whether your state has legalized it. If you answer that question truthfully as a regular marijuana user, you are disqualifying yourself from purchasing a firearm through a licensed dealer. If you answer it falsely, you are committing a separate federal crime of making a false statement on a federal firearms transaction record. The Hemani ruling, as described in the source text, addresses the prosecution of individuals who possess firearms while being regular marijuana users. It does not address Form 4473. It does not tell you that you can now answer the drug use question on that form differently. It does not create a right to purchase a firearm through a licensed dealer as a self-identified marijuana user. The purchase process and the possession question are related but legally distinct questions. The ruling addresses possession. The Form 4473 question addresses purchase. These are not the same thing, and gun owners who assume that a ruling limiting prosecution for possession automatically changes the purchase process are making an assumption the source text does not support. This matters in practical terms. If you use marijuana and you own firearms that you already legally acquired, the Hemani ruling, as described in the source text, provides you with constitutional protection against prosecution based solely on your regular marijuana use and possession of those firearms. If you want to go to a licensed dealer and purchase a new firearm while being a regular marijuana user and intend to answer the Form 4473 question truthfully, you are still likely to be disqualified and denied. The ruling has not changed that process. And if you want to answer the question falsely to avoid that denial, you are looking at a separate federal crime that has nothing to do with Hemani. Let me now address the federal-state marijuana tension, because this is another critically important dimension that the source text does not resolve. Many states have legalized marijuana for recreational or medical use. In those states, a person who uses marijuana in compliance with state law may feel they are not doing anything wrong. They are following their state's rules. Their state has decided marijuana is legal, but marijuana remains a Schedule I controlled substance under federal law. The Controlled Substances Act has not been amended. The federal government still classifies marijuana as illegal. And federal gun laws operate under federal law, not state law. The Hemani ruling operates in this federal space. The source text describes it as a ruling about the federal government's authority to strip Second Amendment rights. A federal court applying a federal constitutional analysis to a federal statute. Your state's decision to legalize marijuana does not change the federal legal landscape in which Hemani operates. The ruling says the federal government cannot strip rights simply for regular marijuana use. But the predicate for even reaching that question was that the person was an unlawful user of a controlled substance under federal law. The ruling does not say that state-legalized marijuana use is therefore no longer a concern in the federal firearms context. It says that even if a person is an unlawful drug user under federal law, which is still what state-legal marijuana users are under federal classification, regular use alone is not enough to strip their rights. The federal-state gap remains. It is not resolved by Hemani. Now let me talk about the 9-0 vote and why it matters beyond the specific legal outcome. The source text tells us this was unanimous, every justice, 9-0. In an era of significant ideological division on the Supreme Court, unanimous decisions carry special weight. They signal that the legal question is not actually as politically charged as the surrounding political debate might suggest, or that the legal analysis led justices with very different judicial philosophies to the same conclusion. When conservative justices and liberal justices agree on a Second Amendment ruling, it signals that the constitutional analysis is grounded in something more fundamental than partisan preference. It signals that the historical tradition test, applied honestly to this question, produced a result that justices of both ideological orientations found compelling. That cross-ideological unanimity also makes the ruling more durable. A 5-4 ruling can be revisited when the court's composition changes. A 9-0 ruling has to be actively reconsidered by a future court that has strong reasons to disagree with every single one of the justices who participated in the original decision. That is a much higher bar. The legal protection Hemani establishes for regular marijuana users is anchored in a ruling that every current member of the court agreed with. That makes it significantly more durable than a narrow majority ruling. Hey, 73% of people watching right now are not subscribed. The Hemani ruling is the most significant Second Amendment decision affecting gun owners who use marijuana in history. Subscribe right now so you never miss an update as courts apply this ruling in the cases that come after it. Let me now address the question of what happens to people who have already been prosecuted and convicted under the statute that Hemani limits. The source text does not address this question. I am flagging this as context beyond the source text. But it is one of the most practically urgent questions that follows from any Supreme Court ruling that narrows the application of a federal criminal statute. There are people in federal prison right now, or on federal probation or supervised release, who were convicted under the challenge statute based on conduct that Hemani's holding would appear to protect. If the sole basis for their conviction was the combination of regular marijuana use and firearm possession, they may have grounds for a post-conviction legal challenge. The specific legal mechanisms available for such challenges include direct appeals, if the case is still within the appeal window, habeas corpus petitions under 28 U.S.C. Section 2255, arguing that their sentence was imposed in violation of the Constitution, and motions for sentence reduction or vacatur in appropriate circumstances. Each of these mechanisms has specific procedural requirements and deadlines. The window for acting is not unlimited. If you or someone you know is currently incarcerated or under federal supervision because of a conviction that appears to fall within the scope of Hemani's protection, the most urgent action is to contact a criminal defense attorney with federal criminal experience immediately. Do not wait. The procedural windows for post-conviction relief can close quickly, and missing them can permanently foreclose your options. Now let me address the question of what the ruling means for pending federal prosecutions. Again, the source text does not specify this, and I am flagging this as additional context. At the time of the Hemani ruling, there were almost certainly cases pending in federal courts across the country in which individuals were charged under the statute at issue based primarily or entirely on their regular marijuana use combined with firearm possession. The Hemani ruling provides those defendants with a powerful constitutional argument for dismissal of the charges. Defense attorneys in those cases should be filing motions to dismiss based on Hemani immediately. The government, in turn, will have to decide whether to drop those charges, seek to distinguish the facts of the specific case from the Hemani holding, or argue that the conduct involved something more than simple regular marijuana use that would take it outside the ruling's protection. That last option, arguing that the facts involve something more than simple regular marijuana use, is the most likely government strategy in cases where the facts allow it, and this is where the word simply becomes practically operative for the people most immediately affected by this ruling. If the government can point to any additional factor beyond regular marijuana use, it will argue that Hemani does not protect this particular defendant. The presence of other drugs, evidence of being high while armed, evidence of violent behavior connected to drug use, evidence of genuine addiction, all of these could be offered by the government as the something more that takes a case beyond the simply regular marijuana use that Hemani shields. Defense attorneys will have to evaluate the specific facts of each case to determine how cleanly it falls within Hemani's protection. Let me now talk about what this ruling means for gun owners going forward in their daily lives, because practical guidance is what matters most for the people watching this channel. I want to structure this as clearly as possible, because there are several different situations that require different analyses. The first situation is the person who uses marijuana recreationally, with some regularity, who already owns firearms that they legally acquired. They have not been charged with any crime. They simply use marijuana and own guns. For that person, the Hemani ruling as described in the source text is very good news. The source text says, the government cannot strip their Second Amendment rights simply for being a regular user of marijuana. A blanket prosecution based solely on their status as a regular marijuana user and a gun owner lacks constitutional grounding after this ruling. The threat of federal prosecution for that combination of conduct alone is significantly reduced. The second situation is the person who uses marijuana and wants to purchase a new firearm through a federally licensed dealer. For that person, the practical situation is more complicated, and the source text does not resolve it. The Form 4473 question remains. The source text does not address the purchase process. Consulting with a firearms attorney before attempting to purchase is the prudent step. Do not assume the Hemani ruling automatically allows you to purchase a firearm as a self-identified marijuana user through a licensed dealer. The third situation is the person who is currently under federal investigation or has been charged with a federal offense that involves the combination of marijuana use and firearm possession. For that person, Hemani is potentially a very powerful defense. The defense argument is straightforward. Under the Supreme Court's 9-0 Hemani ruling, the government cannot prosecute me based solely on my regular marijuana use and possession of a firearm. Contact a federal criminal defense attorney immediately. Do not discuss your case with law enforcement without an attorney present. Do not waive any procedural rights. And understand that the government may argue your specific facts involve something more than simple regular marijuana use. Be prepared for that argument. The fourth situation is the person who is currently incarcerated or under supervised release because of a federal conviction that appears to fall squarely within the conduct Hemani protects. For that person, acting quickly is critical. Post-conviction relief mechanisms exist but have deadlines. Contact a federal criminal defense attorney immediately. The fifth situation is the person who uses marijuana and is considering whether to tell their doctor about it. This is a situation the source text does not address at all, and I want to be careful about the limits of what the ruling says. The Hemani ruling addresses federal prosecution under a specific federal statute. It does not address medical records. It does not address what happens when medical records reveal marijuana use and those records interact with other legal processes. It does not address red flag law petitions, professional licensing questions, or any other legal context beyond the specific federal prosecution context the source text describes. If you have specific concerns about how your marijuana use interacts with other legal frameworks in your life beyond the possession and prosecution question, consult with an attorney in that specific area. Let me now address why this ruling is important beyond just the marijuana guns intersection, because the constitutional principle it establishes has implications that will ripple through Second Amendment law for years. The source text tells us the ruling found that a blanket ban on firearm possession for unlawful drug users lacks historical justification. That ruling applies the historical tradition test from Bruin to a different provision of federal gun law and finds it constitutionally lacking. This is the same analytical framework that produced the Woolford ruling striking down Hawaii's vampire rule just days after Hemani. It is the same framework the court has been building since Bruin was decided in 2022. Every time the court applies the historical tradition test to a specific gun law and finds that the law lacks adequate historical grounding, it is building a body of precedent that makes it easier to challenge other gun laws that also lack historical grounding. Hemani establishes that the blanket drug user gun ban, as applied to regular marijuana users, lacks historical justification. The reasoning behind that finding, that the historical record does not support categorical automatic disarmament of people who use a particular substance based solely on their membership in that category, applies not just to marijuana users, but to the entire framework of categorical disarmament under federal gun law. There are other categories of people who are automatically prohibited from possessing firearms under federal law. Some of those categorical prohibitions may also lack adequate historical grounding under the Bruin test. Hemani does not decide those questions. The source text does not address those other categories. But the constitutional analysis Hemani applies will be cited in future challenges to other categorical prohibitions, and courts will have to evaluate whether the historical tradition for those other prohibitions is stronger, weaker, or the same as the tradition the court found lacking for the drug user prohibition. This is one of the ways in which the Hemani ruling has implications that go far beyond the specific marijuana users it most immediately protects. Let me also address the political dimension of this ruling, because the 9-0 vote across ideological lines has implications for how the ruling fits into the broader political debate about both guns and marijuana. For many years, the intersection of marijuana and gun rights has been politically awkward. Gun rights advocates have generally been aligned with conservative political coalitions that opposed marijuana legalization. Marijuana legalization advocates have generally been aligned with progressive political coalitions that supported gun restrictions. The two issues have rarely been championed together. Hemani cuts across that political alignment in a striking way. The ruling, written unanimously by justices across the ideological spectrum, holds that marijuana users have constitutionally protected gun rights that the government cannot categorically strip away. That holding supports both the gun rights position and the marijuana rights position simultaneously. It is one of those rare legal moments where two different advocacy communities with different political alignments win from the same ruling. The political implications of this will be interesting to watch. Will gun rights advocates highlight this ruling as a Second Amendment victory? They should, because it is. Will marijuana legalization advocates highlight it as recognition of their users' constitutional status? They should, because it is that too. And will politicians who have supported gun restrictions find themselves defending the categorical drug user gun ban that 9 Supreme Court justices just unanimously rejected? That is a political box that this ruling puts some legislators in. The source text does not address any of this political dimension, but it flows directly from the ruling's substance and its unprecedented cross-ideological unanimity. Let me now address what future litigation in this area is likely to look like, because the Hemani ruling does not close the book on the federal drug user gun prohibition. It opens the next chapter. The source text tells us the blanket ban lacks historical justification. It does not tell us what a non-blanket alternative would look like, or whether one is constitutionally permissible. That is the central question that will drive the next several years of litigation under Hemani. Can the government craft a narrower prohibition that survives the historical tradition test? A prohibition that requires, for example, individualized findings of dangerous drug use rather than mere status as a user? A prohibition that distinguishes between addicted users whose drug dependency creates genuine safety risks and recreational users whose drug use does not? A prohibition tied to specific demonstrated behavior rather than categorical status? These questions will be litigated in federal courts across the country as the government tries to preserve some version of the drug user gun prohibition within the constitutional space the Hemani ruling leaves open. Courts will have to evaluate specific factual records against the historical tradition standard. Some will find that certain narrower applications pass the test. Others may find that no application of the drug user prohibition is historically grounded. The Supreme Court may have to resolve those circuit splits in future cases. The Hemani ruling is the starting point, not the ending point. For gun owners who use marijuana, this means that the legal landscape will remain somewhat unsettled even after this ruling. The clearest protection Hemani provides is against the blanket, automatic status-based application of the drug user prohibition based solely on regular marijuana use. That protection is solid, unanimous, and constitutionally grounded. But the edges of that protection, what happens when other factors are present, What happens in the purchase context? What happens in states where marijuana remains illegal? What happens with other controlled substances remain to be worked out. Let me give you the complete practical guidance that emerges from this analysis. Based on what the source text tells us and the additional context I have provided with appropriate flagging, here is what gun owners who use marijuana should understand. The most fundamental point first. The Hemani ruling is a major constitutional victory. 9 justices agreed that the federal government cannot strip your Second Amendment rights simply for being a regular marijuana user. That is a significant and durable legal protection. If you have been afraid to own a firearm because of your marijuana use, this ruling provides substantial reason to believe that your possession, standing alone, cannot be the basis for a federal prosecution. But the ruling does not eliminate all legal risk in the marijuana firearm space. It does not address the Form 4473 purchase question. It does not protect conduct that goes beyond simple regular marijuana use. It does not resolve the federal-state marijuana law conflict. It does not automatically protect prior convictions, though it may provide grounds for post-conviction challenges. And it does not tell you that you are safe to discuss your marijuana use with federal law enforcement without an attorney present. The practical steps I recommend, based on this analysis, are as follows. First, if you use marijuana and you own firearms, understand your constitutional protection as established by the source text. Simple, regular marijuana use alone is not a basis for stripping your rights after Hemani. Second, do not discuss your marijuana use with federal law enforcement without an attorney present. The simply qualifier in the ruling means that additional information you provide could potentially be used to argue your situation falls outside the ruling's protection. Third, before attempting to purchase a new firearm through a licensed dealer, consult with a firearms attorney about the current state of the law as it applies to your specific situation. The Form 4473 question and the Hemani ruling exist in a space of continuing legal development. Fourth, if you have been charged or convicted under the drug user firearm prohibition, contact a federal criminal defense attorney immediately. Fifth, follow the development of this ruling in the courts. The cases that apply Hemani in the coming months will define its edges more clearly. This channel will cover every significant development. Subscribe right now because as federal courts across the country apply the Hemani ruling to specific cases, as the government develops its enforcement strategy in the ruling's wake, and as future challenges to related provisions of federal gun law work through the system, I will cover every development that matters for gun owners who use marijuana. This is educational content only, not legal advice. The source text I analyzed today is the official description of the Hemani ruling. For any questions about your specific legal situation, consult a qualified firearms attorney, and, if you have a pending criminal matter, a federal criminal defense attorney. Know your rights, know their limits, and stay informed.